Good afternoon, Your Honors. May it please the Court, my name is Olin M. Bailey, Jr. I represent the appellants, and with the Court's permission, I'd like to reserve 3 minutes for rebuttal.
All right, thank you.
Your Honor, in this case, the appellants, my clients, filed a complaint to contest the trust. It was a revocable trust created by a settler who had deceased recently. And that settler's name was Mary Ann Tapp. This particular complaint was dismissed by the Chancery Court of Fayette County. The dismissal seemed to be based on jurisdiction or lack thereof. The court certainly had jurisdiction over the trust. The court had been exercising jurisdiction continually since 2016 to 2021 over this particular trust. While Ms. Tapp was alive, the court had actually exercised jurisdiction by appointing a co-trustee, by approving the sale of real property that was owned by the trust, by approving gifts to family members from the trust, by approving attorney's fees to be paid from the trust, approving fiduciary fees to be paid from the trust. The court had exercised jurisdiction continually while Ms. Tapp was alive under the conservatorship umbrella. After Mrs. Tapp's death, the court continued to exercise jurisdiction, and the appellees had actually filed numerous motions after she died, including a motion to approve the accountings of the trust assets, a motion to approve attorney's fees to be paid from the trust, and a motion to approve conservator fees to be paid from the trust. After our trust contest complaint was filed, before our complaint was dismissed, the appellees also filed a motion to approve trust accounting, a first revised motion to approve trustees' fees and attorney's fees, and a motion to employ counsel to defend against our complaint. And then amazingly, even after our complaint was dismissed, the court entered multiple orders exercising jurisdiction of the trust. The court entered an order approving attorney's fees, actually 2 different orders, two for 2 different attorneys, order approving conservator fees and fiduciary fees, one including the co-trustee of the trust, order approving the accountings of the trust assets, and order discharging a trustee from the trust. And a discharge of a trustee has a lot of legal significance because that discharge means there's no review now regarding that trustee's actions. And then the court appointed a successor trustee after they discharged the trustee. All of these orders were entered after the dismissal of the complaint were requested by the appellees during the May 21st, 21 hearing on the motion to dismiss. At that hearing, appellees stated that the court, having jurisdiction over the trust assets, had the authority to remove the trustee, discharge the trustee, and appoint a new trustee, even after our complaint had been dismissed based on lack of jurisdiction. So the appellees seemed to argue that the court had jurisdiction over matters that directly benefited the appellees, such as approval of fees, discharge of the trustee, and appointment of a trustee, but not over matters that seemed to benefit or go against them, such as our complaint to contest the trust. Interestingly, there's still no order at the trial court level where the court relinquished its jurisdiction over the trust or terminated the trust and ordered the distribution of the assets of the trust. It was discussed during the hearing, and it's part of the transcript, but the order entered does not say that the court is relinquishing authority over the trust administration. And as this court knows, the court has jurisdiction over the trust administration under the Uniform Trust Code. The order does state, as an interlineation in the order, that the conservatorship proceeding is now closed and that no final distribution is necessary. And those words, no final distribution is necessary, relates to the conservatorship and not to the trust. The conservatorship had no assets. The trust held all the assets for the ward. So there's no way the court's going to say no distribution is necessary when there's millions of dollars in the trust. So both of those ordering lines had to do with the administration of the trust, the administration of the conservatorship and not of the trust. Therefore, it's our position the court has continued to retain jurisdiction over this trust and has not yet relinquished its jurisdiction over it. Now, appellees make an argument that the appellants, us, filed an adversarial proceeding and an adversarial proceeding. In Tapp, in this conservatorship/trust administration, there was actually 2 parallel proceedings going on from 2016 to 2021. One was under Title 34, which is the conservatorship statute, and the other was under Title 35, which is Tennessee Uniform Trust Code. The Chancery Court has no jurisdiction, I'm talking to a lot of former chancellors, have to be careful here. The Chancery Court has no jurisdiction over a disabled person under the Uniform Trust Code. And the Chancery Court has no jurisdiction over a trust under the conservatorship statute. So we had two different titles being administered in this particular action, one under the Uniform Trust Code and one under the conservatorship statutes. Now, correct, while Ms. Tapp was alive, it was an adversarial proceeding consisting of the conservatorship, certainly adversarial. But there was no adversarial proceeding consisting of the administration of the trust. That was non-adversarial, and that was under the Tennessee Uniform Trust Code. After the death of Ms. Tapp, assuming Ms. Tapp was a respondent, and she was the ward, there was no longer an adversary. So the termination, which is supposed to come first in a conservatorship when you're closing it, and then the closing of the conservatorship was not an adversarial proceeding. So there was no adversarial proceeding after the death of Ms. Tapp. Even if the court said that there was, a conservatorship continued to be an adversarial proceeding, we still had the non-adversarial proceeding of the trust administration under the Tennessee Uniform Trust Code. And contrary to the argument by the appellees, the appellants actually filed a complaint in a non-adversarial proceeding consisting of the trust administration under the Tennessee Uniform Trust Code. Section 201 of the Tennessee Uniform Trust Code states that a court may intervene in a trust administration to the extent its jurisdiction is invoked by an interested person. We invoked that jurisdiction by filing our complaint to contest the trust. And we had to wait until after Ms. Tapp died to do so because the trust was revocable prior to her death and became irrevocable upon her death. And that's a provision in the Uniform Trust Code that says that the trust can't really be contested until after the death of the settlor, even if the settlor didn't have the capacity to, at that time, to revoke the trust, because capacity could come and go. Section 201 further states that a judicial proceeding may relate to any matter involving the administration of a trust. Certainly contesting the validity of a trust is under that particular statute. It falls under that statute. However, once again, the appellees ask for punishment for the appellants, us, but mercy for themselves, because after we filed our complaint, the appellees filed an adversarial action against Charles Ross Simmons in the form of a counterclaim requesting that the Chancery Court not allow Mr. Simmons' attorney's fees to be paid out of the trust. He's a beneficiary of the trust because apparently he had encouraged and enticed us, the plaintiffs, to file this complaint. Certainly a counterclaim is an adversarial action. So they argue that we could not file an adversarial action, yet they did the exact same thing. The very counterclaim filed by the appellees against Charles Simmons was then dismissed in the same order that our complaint was dismissed. It was not a motion. Motions are denied. It was a claim. It was dismissed. And once again, furthermore, the court has still not relinquished jurisdiction over the trust. There is no order terminating the trust and distributing the assets of the trust. And most importantly, there is no order by which the court relinquished its jurisdiction over the trust. It certainly said we're closing the conservatorship. It certainly said there are no assets to be distributed from the conservatorship, but it did not address the administration of the trust in its final orders. I think the jurisdictional issue is important because you have to understand that the chancellor here is dealing with two different titles under the code, Title 34, conservatorships, and Title 35 under the Uniform Trust Code. And certainly he could close or terminate and close the conservatorship under Title 34, but he never took any action to terminate the trust and distribute the assets of the trust or relinquish his jurisdiction over the trust. Now, some may ask, why didn't we just file a separate action under a separate document from the very beginning? Well, first, there was no need to file a separate action since venue was already proper and both personal and subject matter jurisdiction already existed. Second, there would then been two simultaneous actions under two different docket numbers, with the court administering the trust under a docket number A and the court also trying to contest the validity of the trust under docket number B. So one would have been contesting the validity of the trust, and another would have been administering the trust, granting fees, approving expenses, approving accountings, discharging trustees, and appointing new trustees of the trust, of that we have alleged is invalid. Therefore, even if a separate action would have been filed, the next logical step would have been a consolidation of the two actions because they dealt with the same trust. And with consolidations, we're right back into the same situation that the appellees are complaining about, that we filed it in the conservatorship/trust administration action. So that would have not solved the problem. You may ask, why didn't we file a separate action after the complaint was dismissed instead of making this appeal? Well, the appellants had that option. They could have either refiled the action or they could appeal the dismissal of their complaint. They chose the appeal of the dismissal. And if the appellants would have refiled, then the appellants would have forfeited some of the arguments that we had where we say that the appellee/defendants failed, in their responsive pleading, failed to basically make any defenses in that, or waive any, or make any defenses in their responsive pleading. And therefore, they waived all those defenses by not including those defenses in their responsive pleading to our complaint. So we would have forfeited that particular argument. And then third, assuming the Chancery Court did not relinquish its jurisdiction over the trust, which it did not, there would still be a court-supervised administration of the trust happening over here. And those events could incur that the administration would prejudice the contest of our trust. So those events could impact our trust contest complaint. For example, the court could discharge one of the trustees who are defendants in our trust complaint action and appoint new trustees, which happened. Or for another example, the court could also award attorney's fees and fiduciary fees from the trust assets, which would decrease the value of the assets in the trust that we're contesting is invalid. That also happened.
Mr. Bailey, I want to ask you about one other thing here that you haven't mentioned yet, and that's your recusal issue.
Yes, Your Honor.
Did the court ever enter an order on your recusal motion?
No, Your Honor.
Thank you.
Did you comply with the Supreme Court rules in filing your recusal action?
Yes, when we filed our request for recusal of the chancellor.
Yes.
Yes, Your Honor, I believe we did follow the rules. And the court did not enter an order in accordance with the rules stating the reasons why he was recusing himself. He said that he was not going to recuse himself during the hearing, and that's in the transcript, but there is no order stating that he's not recusing himself and the reasons for making that decision.
And your motion or whatever you file, was it supported by an affidavit?
It was not supported by an affidavit, no, Your Honor.
Is that required by the rules?
I believe it is, Your Honor.
And if you fail to do that, are you making an effective motion for recusal if you don't comply with the rule?
Well, certainly you need to comply with the rules, Your Honor.
Okay, all right.
Thank you.
I believe the red light's on. Thank you very much.
Hear from the appellee.
Takes me a little longer to get up here. It's good to see the members of the court again. My name is Hank Shackelford, and I'm from the Madison County Bar. And I've had the privilege of representing Miss Mary Ann Tapp from the beginning of this story, when she determined that she desired to put her assets into a trust and to give those assets to her nieces and nephews. What I would say, I guess, first about the argument of my esteemed colleague, who's a very good lawyer, it's not about what he said today, it's about what he didn't say. He didn't say to you a word about the Acre case. Now, the Acre case is a case that...
Mr. Shackelford, before you get into that, I do have a question. Based on the record, can you clarify for me exactly who you represent in this?
I think I represent Mr. Simmons and Mr. Minor, who were the two co-conservators and co-trustees. Now, at the trial, Mr. Minor resigned and a new co-trustee was appointed, and so that's who I think I represent. I'm not sure that I represent all the beneficiaries. I was never established an attorney-client relationship with them. One of the problems in this case is if you look at the pleadings, there's 11 people in these pleadings that never had anything to do with the conservatorship.
Well, Mr. Shackelford, one of the things in the record that makes that somewhat confusing is on your, I believe, a motion you filed to get an extension of time on filing your brief. You stated in that motion that you represented all of the appellees except one. And
Said
so,
Mr. Charles.
correct. And so then when you filed your brief, it said you represented Mr. Simmons and Mr. Minor. So I'm just trying to clarify exactly who you're here on behalf of.
Part of the quandary that I found myself in this particular matter. But I do believe I represent Mr. Minor and Mr. Simmons.
Okay, thank you.
If you look at the Acre case, and by the way, I think there's only 3 issues that the court has to determine. And once you determine those issues, this case will be resolved.
Pull that speaker, that microphone to you, please.
I beg your pardon?
Pull the microphone.
Yes, sir.
Difficulty hearing.
Chancellor Cole is a good judge. He looked at this case, and he looked at the Acre case, and the first thing that he basically made a determination was that a conservatorship was an adversarial action. That's what it stands for. He made the decision that basically you cannot file another adversarial action within an existing adversarial action. Think back on your days in the bench. Have you ever seen that before? Have you ever seen that before? He also made the determination in following Acre that when they filed their adversarial action, they never asked the court's permission to add defendants. So based on that, he was justified in granting the dismissal of the trust and will contest. He also found, second issue, is that because the issue of recusal, even though Judge Armstrong correctly points out that was never properly raised by not filing the affidavit, that the issue of recusal was no longer an issue. It had been bootstrapped by their attempt to challenge the closing of the conservatorship. And since he dismissed the adversarial action, there were no parties to bring the recusal action. So he properly didn't even address the issue for motion to recuse. And then that left him with one thing, which is all that he wanted to do. He wanted to close out the conservatorship. Why did he want to close out the conservatorship? Miss Mary Ann had gone to Jesus. She was deceased. He had a duty under TCA 343108, which requires when a person with a disability dies or the court early determines a conservator is no longer needed and issues an order terminating the conservatorship shall terminate. He had to terminate the conservatorship. So he did away with their motion to contest the will and trust, said I don't have to hear the motion to recuse. All those other motions that were filed back and forth, he did away with those. He streamlined the case, and he said, we're going to close the conservatorship. The conservatorship, Judge McKee, had no assets. It had never had any assets. Before the conservatorship was formed, she had transferred all of her assets to the trust. The court recognized this when they granted the conservatorship and made the 2 conservators also the 2 trustees. The 2 trustees were meticulous with the dispute with all the siblings running around in making sure that every penny was accounted for. For 6 years, the trustees filed an accounting with the clerk and master who reviewed it. And for 6 years, the judge approved every single expenditure. So all that he was left with, Chancellor Cole was left with, when he made the first 2 rulings, which were proper, was to make a decision to close the conservatorship and move on. He basically said there's nothing that says that he can't file his trust and will contest. He just couldn't file it within this particular action. I think Chancellor Cole's action in this case demonstrates what a good judge can do when he's faced with a difficult situation. On page 18 of my brief, Judge Cole said this. He summed it up. However, the conservatorship action is over. Ms. Mary Ann's dead. The ward is deceased. What we need to do now is close the conservatorship. I don't know if an estate's been opened. Do you have a cause of action you want to file? you have to file that in another action. Just like if you, I believe, if you three were on the bench, I believe that's what you would have told them as well. Instead, they filed this appeal. I direct the court's attention to page 15 of our brief, and this was my first statement in the brief. This appeal should have never been filed. It represents an immense waste of time, expense, and judicial resources. I stand by that statement. Unless the court has any questions, that's just all I have to say about that.
Thank you. Thank you.
Thank you for your time. God bless y'all.
Your Honors, if it pleases the court, Matthew Arnold from the Fayette County Bar, and I represent the odd man out, Charles Ross Simmons. And just a little historical background of why.
You have 3 minutes.
3 minutes. Thank you, Your Honor. And just for the, well, Your Honor, for clarity, I am an appellee. I'm not using the appellant's rebuttal.
Did y'all, I don't know anything about that. I don't know, there's been no division of time here, so.
Okay, well,
I'm sorry, you have no time.
okay. Well, I called.
I was only calling up, the appellant for rebuttal. I haven't been advised that there's any division of time among the appellees here.
Thank you, Your Honor.
Mr. Bailey, you have 3 minutes.
Thank you, Your Honor. First, Mr. Shackelford states that the Chancellor had reviewed the Acre decision before he entered his decision to dismiss our complaint. The transcript says that he did not. He actually said, I haven't read that case, but I believe what y'all are saying about it is true. And the Acre decision is not referenced in the order of dismissal. But I will address the Acre decision. Acre is very distinguishable from this case in many ways. The Acre complaint was filed while the ward was alive, whereas the trust contest complaint that we filed was filed after the ward had died. The Acre complaint was deemed and converted to be a Rule 60 motion, whereas our trust contest complaint was never treated as a motion. It was dismissed as a complaint. It was not denied as a motion. It's a big difference. The Acre complaint was deemed as a Rule 60 motion to amend certain final orders in the conservatorship, and the court found that the motion was untimely because it had been filed 5 years after those final orders had been entered. And then Acre and Tapp are polar opposites in one respect.
Can you just explain to us why you were so intent in wanting to file this case within the conservatorship case? I think we're all interested, maybe, in knowing why it's so important and why you couldn't have just filed another lawsuit in the other court.
Because there were, first of all, the conservatorship case was not only just a conservatorship under Title 34, but it was also administration of trust under Title 35. It was two actions at the same time. And I've kind of explained that initially. And so there were things going on with the administration of that trust while they were trying to close the conservatorship out that would have impacted our contest of the trust. The approval of attorney's fees, which would deplete the assets that we're trying to get back out of the trust. The discharge and removal of a trustee of the trust that we had named as a defendant. The appointment of a new trustee, a successor trustee that now we'd have to amend our action on. So the court had been administering this trust for 5 years. And the administration continued after Ms. Tapp died. And the court could have bifurcated those two areas that the court was administering, one being the conservatorship and one being the trust, which is what the court kind of combined them during the entire 5-year period and said this is the trust administration and this is the conservatorship. So the trust could have terminated the conservatorship, closed the conservatorship, and continued the administration of the trust afterwards.
Mr. Bailey, were the funds between the conservatorship and the trust during that 5-year period commingled?
At one point they were. At one point all the assets came out of the trust and went into a conservatorship account, and then at one point, and then they realized there was a trust, and the court ordered all those assets taken out of the conservatorship and put back in the trust. Because at the initial hearing for the conservatorship, although there's no transcript, my understanding is there was no mention of the trust at that initial hearing. But the court approved conservator fees, attorney's fees for the conservators out of the trust assets and took those fees out of the trust and paid that to the attorneys and the fiduciaries.
What do you say would have been the proper way to do that, since the trust, the living trust, was funding the conservatorship? Could it have been done any other way?
I'm not saying that that is improper. We're not asking the court, this panel, to go back and redo all those orders that were entered for 5 years. I'm just explaining that there was some commingling of the trust assets from the standpoint that the trust assets were used to pay the attorneys for the co-conservators.
And so you're not arguing that that's improper?
I am not, Your Honor. Even if I was, I think I'm out of time on that. What I'm arguing is there's two different actions here under the same docket number, the trust administration and the conservatorship. Thank you very much.
I have one other question, if I may, Mr. Bailey. Was there an overlap between your clients in the trust action and the parties to the conservatorship?
Was there overlapping? Well, obviously, they were all next of kin of Ms. Tapp, so they would have been named as next of kin that had gotten notice from the initial filing of the conservatorship.
Were a portion of them not petitioners in the original conservatorship?
I think one or two were not because they didn't want to be involved, but they were certainly noticed to be part of the conservatorship.
Thank you.
Thank you.
Thank you. Let me be dismissed.
Thank you, Commissioner, to withdraw.
That'll be the conclude court for today.
All rise.